Good day and compliment, dear esteemed viewer, and welcome to our today's edition of Citizens and the Law. Directly today, we are going to look at quit notice and tenancy agreement in law. By the way, Citizens and the Law is a program aimed at letting the citizens know their rights, defend these rights, and then become law-abiding citizens. In our today's edition of Citizens and the Law, we are going to look at quit notice and tenancy agreement. And I have with me here in the studio two gentlemen to get the I's and T's dotted and crossed vis-a-vis provision of answers to all the questions. I have here in the studio a gentleman who has his master's in international affairs and diplomacy, BSc, government/public relations or public administration, a UK diploma in public relations. He is a prolific writer of more than 20 books, property manager, and in that direction, a pioneer in property management. I am talking about no other person than Chief Course Okwoma Damian JP, of course, a community leader. Chief, you're welcome to the studio.
You're welcome. Thank you.
At the other end, I have my good friend, a very good lawyer indeed. I'm talking about Barrister Larry Emeka Nwangu. Larry Emeka Nwangu is a tested and trusted legal personality, and of course, a very big man in this program. Come see, welcome to the studio.
Thank you, presenter.
My name is Jude Mascot Obiago, the presenter of this very program. Dear esteemed viewer, you are going to ask questions today because if you are not a landlord, you are a tenant. And I have with me here Cost Damian Okwoma, who is into real estate management. He is here, the gentleman at the center or between me and the council, to represent both the landlords and tenants. That's his area. Let me start directly from the lawyer by asking you, counsel, Larry Emeka Nwangu, can you enumerate on the body and the structure of tenancy agreement? Because we have done part one of this program. Just tell us for those of us who are new on this very topic, if you wouldn't mind, who is a tenant and who is a landlord, before I get to this question.
Actually, when you want to look at the issue as to who is a tenant and who is a landlord, the common explanation thereat is that any person who occupies a building or a flat or a premises, whichever one you choose to call, whether paying rent or not paying rent, any person who also is a service tenant or subservient tenant is also a tenant, but a licensee is not a tenant. So also is a person who occupies a premises under a bona fide claim of ownership.
And who is the licensee?
A licensee can be described as somebody whom you permitted or who you authorize, under an understanding, to put up, for a while. And that person cannot, maybe as a result of state, a day or 2 days, arrogate unto himself, the rights of a tenant.
Okay, now we are going into this very area of tenancy agreement, whereby I say, can you enumerate on the body and structure of tenancy agreement? Okwoma, you have to be very mindful of this very caption, of this very topic, after the lawyer might have come into it, because you are standing between the landlord and tenant. We are not talking about tenancy agreement now. Under this tenancy agreement, counsel, can you enumerate on the body structure?
When you talk of an agreement, most often it is a kind of understanding between two parties. It is a kind of agreed issues between two parties. And then when you now reduce it into writing and endorse or sign on same, it now becomes an agreement. But first and foremost, every agreement ought to have who is the landlord and the tenant. When you look at it, there must be specified within that agreement who is the landlord and who is the tenant. The issue of where such house is situated ought to also be expressly contained.
The address of the house.
The house, ought to expressly be contained in that agreement, because there are certain key elements which must be, agreed upon and endorsed. The issue as to manner and way of payment of rent ought to also be agreed and reduced into writing. The issue of how it could be terminated when you say the tenancy agreement has expired or has been terminated or may have come to an end, it must be agreed and reduced into writing. You also need to reduce into writing the rights that inures to the landlord, the rights as to diligent use of his property without wasting them. It has to be contained therein. The right of the tenant also as to a peaceful enjoyment of the rented apartment has also to be reduced into writing, contained therein. The issue of the property, when you talk about repairs, the minor repairs, who bears the minor repairs and who bears the major repairs ought to also be contained in that written agreement. These are some few basic elements of
including malicious damage.
Malicious damage could also be done by the tenant, because a tenant who is in arrears of rent and is also having quarrel or issues with the landlord might be moving out of that property and decide to commit some malicious damages. In such an instance, that one is an offense on its own, which the criminal law takes care of.
The law can clamp on the person before actually he gets away from there.
Even if he gets away from that place, because criminal law does not, it has no time limit upon which you can bring a criminal charge against an offender.
Okay, now, Chief Cost Damian Okwoma, JP, you've had the lawyer explain the tenancy agreement. You are a real estate manager, and this agreement is always done in your own before, to your notice. You are in the business. What do you have to say about tenancy agreement and its content?
The learned gentleman was very elaborate in his explanation. We have to come from some other perspective of the agreement.
Yeah.
When you talk about damages in the property, that's what we term as malicious damage. Yes, somebody may live in a property for 1 month or 2 months and cause a lot of damage. The landlord wouldn't even know until such a time. But that's something we call tears, ordinary tears and wears. Ordinarily, the landlord, when something is owed in the premises, in that apartment, it's the landlord that is responsible to repair.
Like expired doors and all that.
These things.
Yeah.
Naturally, they wear out.
Okay.
It doesn't concern the tenant.
Yeah.
But then, if the tenant maliciously damages any part of the structure, he ought to be held responsible.
Okay.
And then the other area I want to talk is that in terms of the agreement, the landlord and the tenant has to agree whether the tenant will be a monthly tenant, a quarterly tenant, a 6-monthly tenant, or a yearly tenant.
Yeah.
And this has implication in terms of the quit notice that will be issued to the person.
This quit notice, does it have expiration?
That's what
does it expire, Council?
When you issue a quit notice,
tenancy agreement, does it expire?
It depends on the clause which the agreeing parties decides to use. They can say that the tenancy agreement runs yearly and expires, and a new tenancy agreement comes in. It depends on their choice of word. So they can say that the tenancy agreement is renewable every upon a fresh negotiation, because some also can run when there is any change in rent price. The landlord can write the tenants, notifying them that he is about to increase the rent as a result of economic realities and changes. So tenancy agreement can expire, given the understanding between the two parties. It can also run till the end of that transaction between the two parties.
So let me add, what can lead to eviction vis-a-vis the tenancy agreement? What can then lead to eviction? This quick notice, what can lead to it? Having endorsed a tenancy agreement. Ogoma.
All right.
Okay. After a tenancy agreement, at times, you people that are into real estate used to issue out quick notice. I want to know, are these conditions of quick notices or eviction contained in the tenancy agreement? Under what and what and what condition do you begin to issue quick notice? I know the major thing is house rentage.
The house rentage, precisely, then the default of any portion of the agreement is can equally determine somebody's, or rather, incur somebody quick notice. Let me chip in something on what the lawyer had said about the expiration of tenancy agreement. More especially where you have corporate entities, corporate organizations. Each time, if it is 5 years, 3 years, 2 years that they pay, it is clearly stipulated in the agreement that at the end of that 3 years payment or 5 years, that the tenancy should be renewed. That's where it is
okay,
common.
I want the two gentlemen to prepare your minds about if there are types of tenancy agreement. But just before that, there is still viewer, you are watching Citizens and the Law on ABS Digital TV of ABS and Channel 2 for Oka. You can also get us on Star Times 113 or Metro Digital 29. Just before we continue, let's have a break. Okay, I want to ask you, Counsel, if there are types of tenancy agreement.
There are types of tenancy agreement.
Yeah.
Common tenancy agreement in Nigeria most runs, maybe when you talk about residential accommodations, most often in Nigeria it is a monthly tenant or quarterly tenant, or you can have yearly tenants, and otherwise it depends on how the agreeing parties intends to. But the only thing predominant governing most of them has to do with the issue of how you can eject. The law is very strict when it comes to possession. When it comes to possession, because of what is prevalent and common in Nigeria, where situations, some landlords can, just because you did not greet them, they can wake up one morning and remove your roof and expose you to the hazard of the weather. So in such a situation, our law here tends to tilt more towards the tenants. It tends to protect them more. That is the reason why this classification of types of tenancy, when you intend to, regain possession as a landlord, you must diligently and strictly, follow the laid down procedure. Failure to do that, everything amounts to a nullity. Whatever you have done, you have to start it afresh. That is the way the law is.
Let me ask you another aspect of question that is close to this tenancy agreement, Chief. As a real estate manager, I understand that many of the buildings, not the ones you manage alone, do not have this tenancy agreement.
Yes.
Can you tell us why many of the buildings, the landlord and tenant agreement does not exist? From your experience, can you tell us why it is so?
Yes, sometimes it emanates from the carelessness of the landlord. Otherwise, ordinarily, the landlord should seek protection through the tenancy agreement. And where there is no tenancy agreement equally, I think it is more advantageous to the tenant in this case. But the landlord may capitalize on that non-existence of tenancy agreement and decide to narrow down the quick notice to 30 days, because it is not stipulated in the agreement that it is 30 days or 6 months or 1 year, which will determine whether it will be 6 months notice or 3 months. where there is absence of tenancy agreement, the landlord may decide to issue a month notice.
Just to take actions at his own whims and caprices. Now, Council, don't you think that the court will be filled with landlord and tenant case if there is tenancy agreement here and there? Because the inability to pay at the expiration of 1 year and 2 years is always the case. Don't you agree with me?
Actually, before I go into this question, sometimes, the non-existence of tenancy agreement also have a checkmate or a guide in order to protect the tenant also. You remember that I said that our law is crafted in such a manner that it seeks also to protect the tenant against the landlord overbearing with. So in such a situation where there is non-existence of tenancy agreement, the court will now look into the mode of payment as to determine if that person pays yearly, automatically the court will deem the person as a yearly person. So for you to the receipts of payment, the court will now say that this person is a yearly tenant, irrespective of
the absence of
an agreement. So also if he pays quarterly or he pays monthly, the court will say he is a monthly tenant. And that is by the way. And
from what you said, it means if that person is consistent, maybe in paying yearly or 6 monthly or 3 or quarterly.
A situation, because most of the times
somebody paid for 1 year, the year passes. The other year now, he's not able to pay 1 year again. He pays for 3 months. He paid for 3 months.
Maybe, yeah.
And after the 3 months, he paid for 6 months. And after 6 months, maybe for a month or 2.
In such a situation, the court will come to a reasonable conclusion as to what will be fair, since there is no consistency in the mode of that tenant's payment. So the court will come to what is most fair in the circumstances. Exactly.
Okay, dear listeners, you are still watching Citizen at the Law on ABS Television, Channel 2 for Oka. You can also get us on Star Times 113 or Metro Digital 29. We are opening the lines right now for viewer to start asking questions or making contributions. You can call us on the numbers there clearly written on your screen, or I can still tell you the numbers 070-627 070-627-24192, 070-627-24192. The other number is 090-729-72090. I repeat, 090-729-72090. You can call to ask questions or to make contribution. So we forge ahead. What I may want to know is what are the basic duties of a tenant? I come to you, Chief Cost. What are the basic duties of a tenant? Before you begin to say this tenant must go or stay, it has to do with the basic duties. So what do you expect from a tenant?
The landlord ordinarily would expect his tenant to live in the premises, number one, peacefully, without conducting himself as a nuisance to other tenants in the premises.
Where do you have a caller? Excuse me. Hello. Hello. Excuse me. Hello. Your name and location.
Hello.
Yeah. Hello. What's your name?
Good evening, sir.
Good evening. Your name and location.
Yes, sir. My name is Mr. Michael.
Yeah, Michael. Where are you calling us from? Where are you calling from, Mike?
Calling from Anambra State.
Where in Anambra State?
From Iftedunu, Anambra State.
Oh, very good, Mike. You are calling from Iftedunu, but adjust the volume of your TV set so that we can hear you clear. Tune down the volume a little bit. Just what to volume TV we better. Can we can feel? Okay. You are free to speak in Igbo language or English language.
I have a question.
Go ahead. Go ahead.
My question is that a tenant is going for someone and wanting to quit and is refusing to quit. How do I throw it off?
A tenant is owing for 4 months. Come again. You said the tenant is owing you. Is owing for 4 months. And you want him?
It's going for 4 months. We usually pay 3 months, quarterly payment.
Yes.
And it's only for 4 months and they have not paid.
Okay.
And now he said he's making trouble. I want him to leave the place.
Okay. You are now asking for the necessary legal. You want to know. You want to know what to do.
The good message.
Okay. Mike from Iftedunu is having a problem with the tenant. The tenant has been paying him quarterly, and this time the quarterly failed, and the thing has metamorphosed into additional 1 month. So, lawyer, advise Mr. Mike on what to do.
Actually, if the issue has to do with the rent, you don't necessarily need to eject the tenant from the rented apartment. Yes. You can sue the tenant and claim arrears of rent, which the court will also grant to you. It's only when you actually want to make use of that property, maybe there is a need for renovation of the said property, that you need, and some other issues also that you need to go for possession. Possession should be the last thing. If the only offense the tenant has committed is non-payment of rent, you can claim just for the arrears of rent, and the court will grant you.
But the landlord wish now is leave my house.
Sometime that wish, the law does not look at it. If it is the rent that is the major problem, the law will be so willing to grant you arrears of rent, except you hinge the claim on another thing. If you say he is owing you rent and you want him to leave your apartment, the court might not be too willing to grant that prayer. because there must be in breach of the terms of the agreement, because these are some of the grounds upon which you can take hold of possession.
There seems to be an agreement in place. Either it is in utmost good faith or written, because the landlord said every 3 months. That has been the mode of payment. But this time,
no, what I'm saying, from what he has said, he says he is owing him. Rent is the issue.
Yeah.
Rent is the issue. If rent is the issue, he will claim for arrears of rent and he will recover it. If the tenant is unable to pay, he can levy execution. He can levy execution on whatever he has, except his wares. He cannot levy execution on his wares.
Damian, I want you to come in here. Remember, you are still asking questions on the basic duties of a tenant. But now, I want you to also come in here.
You see, an average landlord, from my experience, what is so important to him is his money than any other thing. Yeah. That is why whenever you are in 1 month, he becomes very uncomfortable. And when it comes to 3 months, 6 months, and the rest of it, becomes worse. So, actually, it is, to seek redress in the court, to follow legal process, is always costly. The landlord is taking, say, 15,000 naira, and engages a lawyer to recover maybe 15,000 naira into 3 or 4.
5,000.
And you look at it. So sometimes the landlord looks at it and decides. I'm now talking from my experience in the hands of the landlords. He may decide to actually get that person to bring somebody who may be paying him. It becomes his. But then, like the landlord friend said, the law, the court, does not actually grant such easily. Yeah. Like he rightly pointed out, the tenancy the tenancy law of this part of the world is in sympathy with the tenant more than the landlord. So the right thing to do is to go for recovery of that for the recovery of the areas of rent. When the landlord looks in and discovers that going for that one will be at a loss to him, he now decides to actually reject the tenant and bring in someone who can pay.
Okay. So, do you agree with him?
No. My point is that if you are going for recovery of possession, you must hinge it on something. Not just that he is owing you rent, because there is a remedy to rent recovery. That is just the point I'm making. So if you intend, the lawyer will know the grounds upon which possession can, be given back to the landlord. So you cannot just hinge it only that he is owing you rent. When the law has provided a method and a way you can recover the arrears of rent, he is owing you. That's the point I'm making.
Okay, Mr. Mike from Fitedunu, I think your question has been answered. That's the landlord I'm talking to now from Fitedunu. You have to work very well by taking the young man to court to recover your money from him. But if there are some other good reasons as to why he should leave your premises, you still have to go to court. But it's always good to have a good tenant who is ready to pay his rent at the expiration. That is always the best thing, to be in a good hand with your landlord. Chief Constable Damian, you were answering questions on the what you expect from a tenant, the basic duties of a tenant. You already said that nobody wants a nuisance to live in his premises. What are the basic duties?
Any act of criminality is equally the landlord.
They're all nuisance.
Yeah. Then the tenant need to live there to protect the property he's living in, and not to cause unnecessary damages on the property he's living in. He has to live in peace with the other tenants, and be prompt in payment of his rent. Then the landlord has no other thing to do than to allow him to enjoy the premises when he's doing all these things. Okay,
Counsel, most times we used to hear that real estate managers used to drag tenants to court from behind without their knowing it. And the day they know, it is getaway day. that is a eviction, forceful eviction or something of that nature. And that will now make me to ask you to enumerate on the legal processes of evicting a tenant. What process does it take? Does it require taking the person to court without his notice, things like that? I'll come back to Chief Kosokoma Damian later.
Actually, there are elaborate provisions in our law on of recovery of premises. When you want to recover the premises which you have rented out to a tenant, you must strictly adhere to those provisions. There are basically notice to quit, which you must issue in accordance to whether or not the tenant is a monthly, quarterly, yearly tenant. You must issue those notices in accordance with that. And when if it is a monthly tenant, you talk about 30 days because in our, it is the Gregorian calendar, that we use in tabulation of 1 month notice. So the Gregorian calendar is 30 days, and that is the way you will effect that notice. And that Gregorian calendar doesn't run month to month. Maybe you issue the quick notice in this February. Today is 11th. So it will run from March. It will run from March till the end of March. You can issue it this February, but it will be calculated from March to end of March. It does not run mid-months. So that is the way the Gregorian calendar is structured. That is what applies. Then, it is also expected that at the point of termination of that quick notice, the issue of landlord and tenant, ceases between you and the tenant. You are no longer, the law will now address the owner of the building as the owner, and why the tenant becomes an occupier of the building to enable you serve that tenant with what we call notice of owner's intention to recover possession. And a 7 days notice. At the expiration of that, then you can now file your claim. And both of you will come before the court and canvass your arguments. After looking at the whole thing, the court will now decide on whose favor the argument takes and rule. That's the way you can recover possession in Nigeria.
Well, on this note, dear esteemed viewer, we have come to the end of today's edition of Citizens and the Law. We may have to visit this topic again to enable us drive home all the points already noted to be treated here. I want to say a very big thank you to Barrister Larry Emeka Nwangu for coming. Counsel, thank you very much for coming.
Thank you, the presenter.
And I also extend my greetings. I want to thank you very much, of course, Damian Okoma, JP of the Royal Priesthood International Limited. Thank you very much for coming, sir.
Thank you, presenter.
And I am Jude Mascot to be with the presenter of this program. Thank you very much, dear esteemed viewer, for being part of it. We are coming back in continuation of this very topic. We want to come to the end of it. Tenants and landlord, which way to go. Until then, it's bye for now.